Okay, thanks, AJ, for the paper. I have a pretty narrow question, and that is, what do you make of the persistent refusal for First Congress to amend the text of the 10th Amendment to include the term expressly delegated in it? Apparently, it was done was attempted a couple of different times and rejected. The anti-enumerationists make a big deal about that, and I'm just curious to know. And there are different ways of explaining why they refused to do this, but if the position about express delegation was as obvious and universal as the paper really does seem to claim, it would think it would be a no-brainer to include that language in the text of the 10th Amendment.
I just want to focus in on the discussion of Justice Wilson on page 34, and to suggest that you might want, well, make it stronger than that, you ought to discuss other parts of Wilson's opinion. And in particular, I think you must discuss this passage. To the Constitution of the United States, the term sovereign is totally unknown. There is but one place where it could have been used with propriety, but even in that place, it would not perhaps have comported with the delicacy of those who ordained and established the Constitution. They might have announced themselves sovereign people of the United States, but serenely conscious of the fact they avoided the ostentatious declaration. So Wilson's theory, of course, is that the people instituted the Constitution, that it's an act of popular sovereignty, and that there is no transfer of sovereignty from the states to the national government. So that's obviously contested at the time, but I think you have to discuss Wilson's view here. There are others who hold this view at the time, and if they, under their view, your theory just, I think, fails. So I think it must be discussed. Second thing, I'm not saying your theory fails, I'm just saying you have to discuss this if you want to make your case out. Second thing I want to say is very minor, but the Treaty of Paris is a treaty that, as conventionally understood, does transfer sovereignty. And there are cases decided under the Treaty of Paris early in the Republic. So I don't know, but I just think it would be profitable for you to look to the Treaty of Paris cases and see whether these sort of canons of sovereignty transfer interpretation were invoked or applied in those cases. To the extent that they were, then I think that offers strong evidence for an important part of your argument.
All right, thanks so much. So first, I just have a clarifying question and then two substantive things that I'll get through quickly. So the clarifying question is, I'm just a little unclear about what the transferring of a sovereign power category is supposed to capture. So on page 58, it seemed like you were dealing with power conferring versus some sort of sovereign autonomy restricting. But it seems to me like one of the sovereign rights would just be the power to exclusively exercise sovereign authority within a particular jurisdiction, which means like literally anything would be a transfer of a sovereign right, any sort of power in addition. And then on top of that, there's just a massive levels of generality problem, like how do we identify what sort of clarity is required at what level of generality, and I was never clear about exactly how that was working in the cases that you're talking about, and it seems to me like if it's working at every level of generality, then it just sort of bleeds into a strict constructionist view. So I was kind of confused about how that worked. On the international law of nations stuff, I was just a little worried here that the law of nations, although recognizing a category here, isn't actually telling us what to do when there isn't just a transfer of sovereign authority, but is actually a transfer of sovereignty itself, and then the government that is constituted is a representative government. And I just wonder what the law of nations has to tell us in that context, since the law of nations is dealing with confederated principalities. So it seems to me like plenty of people in the American early republic have perfectly plausible arguments for distinguishing that. And then the last thing I just wanted to ask is how the McCulloch discussion, Gibbons, fits with the Dormant Commerce Clause jurisprudence that the court was alluding to, and that, like in Elkins, and I know you've talked about this in the in the Columbia paper, but it seems to me like the Dormant Commerce Clause discussion is sort of a counterexample that maybe tells us that what the court is doing in McCulloch is embracing a different conception of what the Constitution is doing, which is to read the federal Constitution as analogous to state constitutions and not as a sort of international instrument. Thanks.
Great. Thank you all. Randy, why did they refuse to put in the word expressly? It's a great question, and you know, the best I can tell, and I mean, this is something we definitely need to talk about in the paper, is that there was a concern that if they put in the word expressly, it would counteract the ability of the federal government to exercise any incidental powers. And that was a real concern given the failures of the Articles of Confederation. There's nothing in what we're talking about that would preclude incidental powers, and I think there was a concern that if the word expressly had been put in, then that could lead to a strict construction of the necessary and proper clause and essentially debilitate the government. And I'll say more about that, I think, when I respond to Judd. But we definitely have to say something about that. Yeah, Larry, I mean, your comments are spot on. We need to do more with Justice Wilson. And there's something going on in this paper that at least I've been trying to get away with, and I'm not sure that I can. Trying to sort of build a bridge over, was the Constitution established by the states? I don't think so. Was the Constitution established by the people of each state? Madison, Federalist 39? I do think so, and I think the theory works with that. Or was the Constitution established by the people of the United States as an undifferentiated whole? If it was, and assuming that there were sovereign rights and powers in the states that the ratification of the Constitution divested, then I think an argument can be made that no matter who divested them, in the instrument that they used, the same rules would apply. If that doesn't work, then yeah, I've got to stick a flag in the ground and say the Constitution was established by the people of each state. And yes, as far as the Treaty of Paris goes, it would be well worth looking at those materials, and we have not. So Judd, what does the transfer of sovereign rights include? Yes, the exclusive power to regulate people and things within the territory. The Constitution clearly divests the states of that exclusive right relative to certain objects, and they're enumerated. But here's the difficulty. You know, here's kind of the trick. I actually think, and I mean, this is something we need to explain. I mean, we talk about this. I need to explain this a little bit more, and this is part of the paper that I didn't ask you to read. Maybe some of you did, some of you didn't. But I think that people like Jefferson and Tucker latched onto this rule to say that every allocation of power, like the commerce power, because it is divesting a sovereign right to territorial control of people and things, must be narrowly read, right? It's got to be express. And what is express about commerce? Well, I think the way the rules actually operated was the way that they operated in Gibbons, where Marshall said right at the beginning, it's argued we must strictly construe this instrument. But where there is an express allocation of power, and here there is, the sovereign right of the states to exclusive control within their territory has been divested with respect to commerce. It's clear. And so our job now is to understand what the ordinary and customary natural meaning of commerce is. This was a difficulty. I think this actually was a difficulty with the interpretive rules. I think reading the rules as I do, Marshall had the better of the argument than Tucker did, but I think you put a finger on, the main question as to how these rules actually applied. And territorial sovereignty is the one that generates these real difficulties. I don't think others are all that difficult. One of the sovereign rights is to make a treaty. The Constitution clearly divests that from the states. To make war, it's mostly divested from the states. The right to control one's government. You and I have both written about this question. That one I don't think was clearly divested. Sovereign immunity, of course, falls within this category. But upon examination, I think the sovereign rights and powers that existed were a more discrete set and less amorphous than we tend to think that they are. And as far as McCulloch goes, the first part of McCulloch, does Congress have the power to establish the bank? Understanding the necessary and proper clause in accordance with its ordinary and natural meaning, and I read McCulloch as kind of a compendium of Vattel. He almost goes through all of it. But there's one part of McCulloch that's always edited out, nobody pays much attention to, and it was this argument of counsel that Congress doesn't need to establish the bank. It's not necessary because Congress can just use the state banks. And Marshall said, well, no. Congress can't be left to use a state instrument over which it has no control. It can't make the states establish banks, and once it does, Congress can't tell those banks how they have to operate. Just sort of takes the commandeering thing for granted in the same way that Justice Story sort of took the commandeering thing for granted in Prigg. But that wasn't really your question. You were asking about the Dormant Commerce Clause, where Marshall was, well, maybe not. And I think the difficulty there is, for there to be a divestiture of sovereign rights under these rules of interpretation we're talking about, it's got to be express, or it has to be a necessary implication. And Wilson puts it this way, in the part of his opinion in Chisholm that's actually applying the rules. And I think the hard part with the Dormant Commerce Clause for Marshall was, is it a necessary implication of the allocation of the commerce power to the states that the states are divested, or to Congress, that the states are divested of it? So I'll stop there.
I enjoyed the paper, AJ, and I enjoyed it in part because I thought it was interesting, but I also favor the rule that you described just on normative grounds. But I also had some of the reactions that other people had. I think with respect to this 10th Amendment problem, I think you have a pre-10th Amendment problem, right? Because you quote the articles and they mention that all things that aren't expressly given to the federal government are reserved to the states, but that's never made part of the Constitution originally, and of course it's never made part of the 10th Amendment. And so why can't someone say in response to your paper, they basically abandoned the rule of express powers by not repeating it, right? So there's just an intertextual argument there, independent of international law. Look at the particular feature of these two, if you want to call them treaties. One has a different character than the other because they don't repeat this language. And interestingly enough, Marshall cites that in McCulloch, right? Because he says that this expressly word is not in the Constitution, even though it was there before. So you're left with, I think, arguing something like it's clearly authorized even if it's not express, I think, or that the bank is somehow clearly permissible or it's clearly given away as an incidental feature, even though it's not expressed. And then, I had a Judd's reaction to the Dormant Commerce Clause as well, because I don't regard that as a clear feature, something clearly given to the federal government that the states can't regulate commerce. And so I thought it was a problem for you. But the final comment I'll make is, I thought all the cases were problems for you. I just didn't think that the cases fit the theory, not because I don't like the theory, I just don't think these justices had that theory or were willing to apply it to the new instrument. And trying to make it seem as if the justices were applying it, I thought didn't make sense of the cases as I understand them.
Okay, so I thought it was a really interesting paper, and I sort of took some old ideas and turned them into a kind of novel, kind of modern view, because they're not so much part of the modern world. So much of what I want to say, I guess, is touched on by Ingrid and others. So I understand that your claim is that it has to do with the transfer of sovereignty. And by itself, that's enough. That satisfies the Vattel rule. But I guess I wonder, what is the earliest, how can we be reassured that that's actually what's operating here? And it'd be helpful to sort of have the, people talking about that. And Ingrid kind of mentioned some of this, but, what is the sort of earliest example of people even talking about the Constitution as a compact even? And of course, and even better would be saying something about this rule. The earliest example that I know of people actually saying that the Constitution was a compact, as opposed to it should have been, objecting to we the people rather than we the states, is Madison in the bank bill says a bit about, the bank debate says a bit about how this is kind of a contract, but he's not entirely there. So now certainly by 1798 and the Alien and Sedition Acts, people are talking about that, but I'm just sort of wondering if it's a kind of response to what's happened, but not there in the beginning. So especially because, if we have a treaty between two nations, you're worried about war happening. It's not at all clear that that same rule is going to apply in a federative situation. So I recognize some people talked about this already, but.
Yeah, I wasn't going to ask any question until I was when Ingrid was making her comments, and she juxtaposed interpretation and validity, and I thought about that, and I was wondering. So I have this, So let me just ask about the relation between interpretation, which we do all the time, and rules of interpretation. Now, you could look at rules of interpretation as heuristics, right? This is the best way to find out what the meaning of something is. And of course, if it's a heuristic that someone is going to use, then of course you will try to fashion your expression in light of the heuristic so that you close any potential gap, or you try to. But nonetheless, the gap could be there. So an originalist might say, this is the best evidence on this is that this is a meaning that nonetheless isn't so clear that it satisfies the Vattel rule. And then the question is, are you really then just saying, if the meaning isn't clear enough, then despite the fact that it has this meaning, nonetheless it's invalid. It's an invalidity rule as opposed to an interpretive rule. I kind of like thinking of it as an invalidity rule rather than an interpretive rule, because there's no necessity for an originalist to say, well, it looks like it means this, but then there's this other rule that we superimpose on it, and that changes its meaning. I'm not sure that that's what's going on.
Yeah. So I'll start with that, Larry, because I have the most incomplete answer, which is this has been something of a tension in the paper and something we've been trying to work out. I think I've been coming at it more from the rule of interpretation angle, and my co-author has been sort of more working toward validity, and as you can tell in the draft, we're still trying to work this out, and that's about the best answer, that I can give. As far as the, abolition of the word expressly went, it was in the Articles, it's not in the Constitution, and it's not in the Constitution even though it was proposed to be in the Constitution. I think one element of this is that the Constitution existed before the 10th Amendment existed, and it's a whopper of a negative implication in light of the rules of interpretation that surrounded these instruments to say that because this provision wasn't put in the Articles, that all bets were off as far as the Constitution went. I could see by the time of the 10th Amendment there being concern about putting the word expressly in, given sort of these claims of strict constructionism that had arisen. I'm not quite sure I would draw the same negative implication. As far as the observation that the cases don't fit the theory, I guess there I just disagree. You put Barron versus Baltimore on the table. Does the Bill of Rights apply to the states? And it's right there. This one's written in the passive voice. It doesn't say Congress. Does it apply to the states? And in order for the sovereign power of the state to be limited in this way, it's got to be expressed. And I think obviously one of the challenges with reading old cases is that there are certain things that are just taken for granted, that aren't spelled out. And this is where a lot of difficulties in sort of legal, lawyerly historical analysis occurs. And I think in McCulloch and in Gibbons, where you do see, Marshall engage this in some degree to say we have to understand necessary, and we have to understand commerce in accordance with its ordinary and natural meaning. Okay, everybody can accept that that's a generally applicable rule of interpretation. But what do we make of the fact that, of course though, Congress can't make the states make a bank, or can't change the nature of the charters of state banks. There's something going on. There's something going on there. Mike, a few points there. Our argument, just to be clear, does not rest on treating the Constitution as a compact. These rules that we try to flesh out here would apply to a statute, to a convention, to a treaty. I can't plug the Constitution into any one of these categories. But I can identify something that the Constitution is doing, that there was a rule of interpretation to deal with when a legal instrument was claimed to to do that. What's the earliest appearance of any discussion about this? I don't know if it's the earliest, but certainly discussions of state sovereign immunity in the ratification debates were there, and I mean Hamilton made this pretty clear. If something as important as state sovereign immunity is going to be taken from the states by this instrument, it's got to be expressed. And I actually do think that force was on their minds in a big way. When the Virginia plan was first put forward, look, we've got some serious enforcement problems under the Articles of Confederation. How are we going to get around these? Proposal 1, this newly created government will be able to exert force on the states. Well, is this how we're really going to build a system? I think there were real concerns about states resolving their disputes through the use of force. There were real concerns by opponents of the federal government that the federal government with a standing army would exert force to, impose its will on the states. I think that this was all very real, and Madison, did make the point that treating the Constitution, in accordance with these rules would obviate the need for force. It's a long way of saying I think force was something real, even in this context.
I feel like I want to give a trigger alert here to Chris and a few other people in the room. I think this paper is really original in the best sense of that word, and I applaud you for that. I think coming up with anything original these days is very difficult. I was triggered by page 59 in a very serious way. Randy has justifiably, over the last few years, criticized people who are criticizing originalism circa 1980s. And I think Randy's right to criticize those people. Larry wrote an article last year in Constitutional Commentary, or 2 years ago, I'm sorry, I don't remember, called Living Constitutionalism versus Originalism, or vice versa, or something like that. And your page 59, last paragraph, is a triggering event for anybody who doesn't buy into originalism, and I want to make that clear. In Larry's article, he said that the 14th Amendment might not have been understood in 1868 as protecting against gender discrimination. And I think the argument is, even if we know they thought that, as a matter of application, that can change when facts and values change. Actually, the phrase Larry used was facts or opinions about facts change. That's a direct quote from Larry's piece. It is not true that originalists, you write, non-originalism by contrast denies both fixation and constraint and would allow interpreters to update the meaning of the Constitution to take account of changing conditions and mores in society. If you change the word meaning to application, Larry agrees with me. I mean, in other words, the application of things can change, even if we know with 100% certainty what they thought about the application. So the idea that there's this dichotomy, I think, is a really triggering straw man for some of us, that living constitutionalists think we can change all the rules all the time. No, we don't think that. Mike Dorff doesn't think that. Larry Tribe doesn't think that. We think that the principles in the Constitution are vague and imprecise, the ones that get litigated. And Larry tells us that if facts change, then if opinions about facts change, then expected applications can change, and there is not, sorry Chris, a dime's worth of difference between saying the meaning is changing or the application is changing, two judges on the ground deciding cases. So my suggestion to you would be to take out this idea that somehow your thesis supports originalism, but not, or requires originalism, but not living constitutionalism for the reasons you do on page 59. I don't think that's fair.
So, as you can imagine, I loved this paper until I got to part 3C, where I learned that it didn't think it already agreed entirely with everything Steve and I had written. But I confess I'm puzzled about why not. And I think the current draft may underplay the status of general law in ways that are a little puzzling in a couple ways. So the paper refers to the reception and incorporation of general law in a way that might lead you to believe that it's sort of like the state has to make a conscious choice to take some act to incorporate the common law or else it's not incorporated. But not all states passed reception statutes incorporating the common law. My understanding is Connecticut did not. Ohio did briefly and then repealed it, and Rhode Island passed one that only applied to statutes. But everybody assumed that worked the same way, that even without any actual act receiving the common law, it just kind of came. And the Dale article on the reception of the common law you cite even describes it as just kind of like comes with people. When Englishmen come over to America, they just bring the common law with them, like smallpox. So I worry that metaphor is a little misleading, that the general law kind of does flow more naturally. I also worry that the idea that the general law kind of reduces to state law, you sort of say at some point that our claim really reduces to saying it's just a matter of state law, seems misleading in light of Swift versus Tyson, which extensively distinguishes between general law and local law. So general law is something other than just state law. I mean, and I thought you would agree with that in light of your 2013 piece on the status of general law, and maybe I misunderstood the piece or what you think about Swift versus Tyson, but it seems like the status of general law is something different than just local law, and it flows over more naturally. So I would have thought, I don't know, it doesn't quite look like you describe. And then lastly, I'm not sure how the kind of law you describe is any different. It has all the same problems general law does, not being enumerated in the supremacy clause, having to ask how these international law principles or the principles of transfers of sovereign rights from Vattel, whatever they are, how do they get over here and why are they binding and why are they enforce? I think they're kind of in the same boat as the general law. I would have even said they were part of the general law, that principles of international law are one kind of general law, and that's why the law of nations is part of our law. So I would have thought we were kind of more in the same boat, and I'd be happy to get in the same boat and sail the same place together. But if not, I'm going to ask you to walk the plank.
First, AJ, I thought that the discussion of the cases did a better job of showing that Snowis is wrong than of showing that you were right. That is, that they were treating the Constitution as a legal instrument and frequently applying principles that apply to all legal instruments. But what you need is more than that. And I think, especially for some of the cases decided after the compact theory of the Union was in play, for the court to say something that shows that even under the compact theory and even under the principles you're talking about, this would satisfy those principles. That's saying what we have here is a sufficient condition for being right, not a necessary condition. So maybe when they say that, that doesn't mean that the court is accepting that the Vattel principles apply here, but might be kind of thinking, although without mentioning Vattel, that even if so, they are satisfied. On the question, what Larry raised, and you talk, I know we're more mixed metaphors. Or can you build a bridge over this, or do you have to plant the flag? I think we got a bridge collapse. I think that you can't say that the Constitution and get your results, that the Constitution is an act of a single popular sovereign. It's true, an act of a single popular sovereign, one of the phrases you use, an instrument to adjust sovereign rights. So is the Constitution of Massachusetts, clearly just one popular sovereign. That fits into the broader category of an instrument used to adjust sovereign rights. But the Vattel rule is for a narrower part of that category, which is some kind of engagement among independent sovereigns such that they can be governed by the law of nations. So I think you have to do the compact theory of the Union. I know you're swearing up and down you don't. But I think you have to do something a lot like that in order to say that this is the kind of thing to which those inter-sovereign principles apply, as opposed to Wilson, no, there's a single American popular sovereign, and it's doing that because it seems to me that if that's what's going on, it's the same as the Massachusetts Constitution, and it's not governed by these rules.
Okay. Thank you. Eric, point well taken. And, it's crucially important that every paper be entirely fair, and your point is well taken, period. Well, yeah, I mean, as far as general law goes, yeah, it was real law, and it operated not as state law, and that one sentence in there doesn't quite capture the way I think about it, and I do agree with you. I guess here's where, and this I just have not thought it entirely through, but as I understand what you've said, you can imagine a world where this universe of background law, general law, whatever it is, interpretive rules change, validly change, and they then would be applied to the Constitution, following the valid change. And what is it that would generate the valid change? Constitutional amendment clearly would be fine. There's other ways. You could think Congress enacting rules of interpretation. I say, well, no, that wouldn't be a valid change. But if it was just sort of a general law evolution where these rules of interpretation change, and we understand that they exist under a rule of recognition, I guess there, I'm okay with that as long as what we're talking about then is constitutional law and not the Constitution. Because if the parallel world of law changes and then applies back to the Constitution, which was forged, if we're right, which is an if, in light of other rules of interpretation guiding its meaning, then you end up having sort of random outcomes. And so, I mean, that's where we just have to think harder about where exactly we are with respect to you. John, yeah, I mean, the hard part about the really early cases is that they don't necessarily tee up these issues. And yeah, I mean, we've looked for certain hints in them, right? Congress's power to tax the carriages. Is it a direct tax? And you get these bits and pieces of, well, if it's a direct tax and it's got to be apportioned, we're going to have to collect it from the states, and that's kind of a big deal, and so we're going to shy away from that. And it's not a direct tax. You see it, but these issues aren't teed up. So, yeah, it's a legal instrument. I think from the get-go, it's treated as a legal instrument. What work is the rule of interpretation we're identifying doing? Limited, because the issue wasn't directly teed up in these cases. I agree with that. And you may well be right on the people of the United States versus. I mean, your point, Larry's point. It's very well taken. And just to think out loud, the only way that this works is if there is, at the time that the Constitution goes out for ratification, states that have sovereign rights and powers backed by an ultimate sovereignty in the people of each state. And somehow this collective of people, I'm not quite sure how, because the Constitution's not going to be binding on states that don't ratify it. So maybe I'm just sort of working toward the theory I want to, and I don't need the bridge. But somehow these people operate to, from on high, divest the states of these rights and give them to the federal government. You could see one way in which the theory works. It's a form of, I don't know if I use the word conquest, but it's sort of an involuntary divestiture, right? I mean, in a sense. But that's not how it actually went down. So maybe I don't even need to go down that road and, sort of elicit grimaces. Maybe it's just, look, the Constitution went out to the states. It was ratified by the people of each state, and that's simply good enough. Madison was right. Yeah, point's well taken.
Thank you very much for this paper. I wanted to propose a bridge. And especially since you're at Notre Dame, it might be appropriate to look at Orestes Brownson's book on the American Republic in 1866. And it maybe is just a way to, with words, combine things that are irreconcilable. But he points out that the people of the United States, they don't exist as a people. the people of the United States. The states never exist independently except as with the people of the United States. The people united and states or colonies are co-evolve. And he says you could never have, the states can never claim a separate sovereignty, but moreover, the people can never claim something apart from the existence of separate colonies or states. Now that may be just a way of just pretending as if there's no distinction, or just trying to elide it, but the sovereign people of the United States, as such, must recognize at least a certain degree of sovereignty exists in the states as such, or they wouldn't even be states if they were just administrative districts.
I think I have about 30 seconds, so I'm going to be real fast here. I have a methodological question, which is, which of the following propositions are you trying to establish? One, that by the nature of the Constitution, it necessarily takes on the interpretive rules that Vattel prescribes for international compacts. Or two, is the way the framing generation understood the Constitution that it took on the Vattel rules for and transferred them over from international compacts to something that's arguably quite different, but could be seen as analogous. I think those are two different propositions. I think each of them has some problems in establishing them, but the problems are different, and I think the paper would be helped by being real clear which of those you're trying to establish.
Okay, I'd try to be real quick about this. I think that going back to Larry's question, I'm not sure that your argument works even if we take the intermediate position that the Constitution was formed by the people of each state acting in that form. Because I think the international law rule that you're contemplating or talking about is a rule where, as you pointed, Vattel said that an instrument was considered odious if it changed the status quo by divesting sovereign rights previously possessed by one of the parties. I think the states have to be a party to the deal. Otherwise, this international law rule doesn't work because it's all about the idea that you can't trick someone into giving up rights that they didn't intend to give up. But in this case, the body that might suffer from an unduly broad reading, which is the state, is not the body that approved the language. It's the people, even if we think of it as the people of the state. And it's impossible to say without making a normative judgment whether the body that created or approved the language, the people, would be harmed by a non-originalist expansive construction of the language or not. So I think the law of nations rule that you're relying on and the reasoning behind it only work if we think of the Constitution as having been constituted by the states rather than the people acting as one whole or even as individual collective state groups.
Yeah, on that I just disagree. It wasn't a rule that applied just to compacts between states. Vattel made very clear these rules apply to any treaty, any compact, any convention, any law, any contract. They applied across the board, although how contracts would figure in there, I'm not sure. But this rule is essentially the kernel of the presumption against the extraterritorial application of U.S. law. It's a momentous thing for any law, whoever establishes it. Is it the state? Is it the executive? Is it the legislature? Is it the people by referendum? It doesn't really matter, because if a legal instrument is misinterpreted to divest a sovereign right, it has serious ramifications, no matter who adopted it. So, I think the theory holds up just fine if it's the people of each state who adopted the Constitution and who, through their actions, ceded sovereign rights and powers to the United States.
We're done.